today. And just briefly, I do want to introduce all of our panelists today, and then I'll provide a few framing thoughts. First up today will be Moneen Nasmith. She's a senior attorney with Earthjustice, who will be discussing liquefied natural gas issues. We also have Justin Meuse, the government relations director with the Wilderness Society, who will be discussing oil and gas issues, both onshore and offshore. We also have John Leshy, who is with the University of California Law School for San Francisco. He will be discussing mining issues. Then we have Dinah, who is a former general counsel of the Council on Environmental Quality, to discuss NEPA issues. Leslie Fields, the chief federal officer for We Act for Environmental Justice, to discuss environmental justice issues. And then batting last will be, but not least, will be Matthew Davis, who is the VP of Federal Policy with the League of Conservation Voters, who will be discussing transmission issues. I wanted to provide a few quick framing thoughts. The first is that we have an immense challenge and opportunity before us regarding a just and equitable transition. Our groups have expressed serious concern with the Energy Permitting Reform Act, 360 plus environmental conservation, environmental justice organizations across the United States. And that concern is because we think that there is a right way and a wrong way to go about the process of permitting reform and accelerating our energy transition. The first is that we think we need to invite people into the conversation about the energy transition to create a sense of shared belonging about what the energy transition entails. And to do that, we think that means you have to account for the broad range of public interest values that people care about. That does include, of course, a reduction in greenhouse gas emissions, but it also includes issues such as public land protection, ocean protection, environmental justice, public health, the way that communities approach the world around them. So an inclusive energy transition, and one that is based on a broad range of public interest values. Last thing I'll say on this front is that the energy transition is a marathon, not a sprint. And I think when we take a look at the permitting concepts in Congress right now, we're worried that we're cutting corners and that this is a mistake and may in fact degrade our energy transition, not accelerate it and strengthen it. I also want to give a shout out to everybody here who helped pass the Inflation Reduction Act, as well as folks in the Biden administration who have already taken great strides forward to help accelerate and strengthen our energy transition, in particular at an administrative level. The Inflation Reduction Act provided $1 billion in funding to federal agencies to help move forward with accelerated permitting, federal permitting. The Biden administration has also modernized implementation rules for the National Environmental Policy Act. And we're seeing results on the ground as we speak. The Department of Energy, for example, has cut in half the timeline to complete environmental impact statements and has additional programs in place to cut again in half the timing for transmission approvals. I do want to also end, before we go to our speakers, to identify the elephant in the room, and that is the net greenhouse gas emissions reductions that have been modeled by certain entities, including the Rocky Mountain Institute. Modeling is a very complicated process. And I am a lawyer, so I will not delve into all of the nuances of that, but I will speak from my area of expertise, and that is federal litigation and environmental and administrative law. When we take a look at the Energy Permitting Reform Act, the key insight that we have is that it does not exist in a vacuum. And instead, it exists as part of a very complex array of economic, energy, and legal systems and political systems at both the federal and state level. I don't think anybody on this webinar needs to be reminded of how aggressive the United States Supreme Court has been the last 3 terms. And so as we contemplate changes to bedrock environmental, public health, and community protection laws, we need to account for how these laws will be interpreted and applied by federal court systems. And on this front, we are alarmed. And so when we see bills such as the Energy Permitting Reform Act that look at weakening bedrock environmental laws, that cannot be understood in a vacuum. It does have to be understood in the context of how these laws will be interpreted by our federal courts, and in particular by a Supreme Court with a 6-3 Republican majority. Last thing I'll say is something from my experience here in the state of New Mexico on the energy transition, which is all of the above energy strategies, in particular concessions to the fossil fuel industry, have downstream political and economic impacts. In my home state, for example, we've seen provisions dealing with fossil gas hydrogen, dealing with carbon capture, derail our energy transition in a state that is otherwise very dominated by oil and gas interests. If we cannot extract ourselves, forgive the pun, from our dependency on oil and gas and speed the transition to clean, renewable energy, we will not succeed. And in New Mexico, for example, we are seeing carbon capture projects and fossil gas hydrogen projects that are looking at perpetuating oil and gas dependency, not actually making our transition. So with that, I want to open it up to our speakers. Again, I want to welcome everybody into this webinar. And if you join late, my name is Erik Schlenker-Goodrich. I'm the Executive Director of the Western Environmental Law Center in Taos, New Mexico, and I will be moderating today's panel. With that, I'd like to introduce again Moneen Nasmith, Senior Attorney with Earthjustice, to discuss liquefied natural gas issues. Moneen?
Thanks so much, Erik. Great to be here. I want to start off by also pivoting off of what Erik says about not considering these bills provisions in a vacuum and recognizing that the Department of Energy plays an incredibly important role, gatekeeping role over liquefied natural gas exports. The volume of LNG that this country exports, how much, how little, do we need more? Those questions have critical implications for a whole host of across-the-board policies and questions, including domestic energy prices, domestic consumer prices more broadly, national security implications, our ability to address the climate crisis, and really critically, something that Leslie's going to talk about in more detail, and Erik's already mentioned, the cost of this industry and that this industry imposes at home falls disproportionately on overburdened communities, particularly those communities in the Gulf. And that is something that DOE has frankly not done a great job of to date in appreciating and addressing. It is something that FERC routinely falls down on the job in assessing, but it is something that DOE has recognized in this recent effort to update its analysis of the impacts of LNG, that it is going to be tackling, something that the Manchin-Barrasso bill doesn't actually remotely address or appreciate. It focuses only on climate and economic impacts. But this is a gatekeeping function we want and need DOE to play. And the bill's LNG provisions seek to have the exact opposite effect. To the extent we have a DOE, and I just want to walk through what this would actually look like if this bill were enacted. To the extent we have a DOE that would be taking responsibility to protect the public interest seriously, the bill arbitrarily shortens the amount of time DOE has to evaluate these really complicated questions of whether to authorize more exports. The statutory standard DOE operates under is that it shall issue an order authorizing export unless it finds that the proposed export will not be consistent with the public interest. So for DOE to have the chance to develop a record showing which way a particular export authorization falls, it needs time to do that. It also needs time to assess if this is truly an export application that would be inconsistent with the public interest, then it needs to have a record to do that. Erik already raised the issue of the Supreme Court, but I think it's important to note that if DOE were to deny any export going forward, that would get challenged by industry, and DOE would need to have a robust showing of why it said no. But the bill's language arbitrarily carves down that time and provides that if DOE runs out of time for whatever reason, for example, maybe there's a major upheaval in global LNG markets that occurs at the same time an application drops or an application is being reviewed. Maybe the applicant isn't being cooperative with DOE. No matter what, this bill drops an absolute axe down on DOE and says that after that 90-day clock expires, the application is granted, even if, in fact, that export volume is not in the public interest. I really want to be clear that to the extent this bill is being characterized as setting that 90-day clock to start only after an environmental review is finished, that is incorrect. The bill keys the start of the 90-day clock to several different events depending on what applications you're talking about, but none of those triggers occurs at the completion of DOE's environmental review. For new applications to export, the text of the bill very plainly refers to the completion of the environmental review for the terminal, not the export. So it's FERC's environmental review. And FERC only looks at the environmental review of the terminal. It does not look at these broader implications that DOE is charged with looking at. Even worse, for applications where FERC's environmental review has completed, the bill triggers the 90 days off of the date of the bill's enactment. So nothing having to do with where DOE is in the process or what more DOE has to look at. And that trigger applies to projects like the massive unprecedented volume from the CP2 project that is pending before DOE right now. Also, the bill for applications to re-export, there is a significant volume of LNG that is being contemplated going through Mexico and being exported from terminals in the coast of Mexico. The bill keys that trigger to a draft environmental review, not even a final environmental review. And then for applications to extend existing authorizations, because these authorizations only last for a certain amount of time, if the company doesn't get the exports online soon enough, they often go back to DOE and say, we need more time. We're talking about data then and a finding by DOE that is years old. It's sometimes 5 or 6 years old. And the bill would only give DOE 90 days from the date of the application, not an environmental review, not any kind of actual time, an arbitrary cutoff designed to force DOE to either say yes by virtue of the clock expiring or say yes by virtue of the statutory standard. Even worse, that everything I just described presupposes that we have a DOE that actually takes its job under the Natural Gas Act to protect the public interest seriously. We have, in the not so recent past, seen examples of DOE that are more structured towards giving the fossil fuel industry the green light to export and develop all of the fossil fuels. This bill sets up a path of no resistance where DOE could sit, do absolutely nothing, and by virtue of the passage of time, all of the LNG exports would get approved. So it doesn't matter what would be in the best interest of the American people, of consumers, prices, nothing. It would all be just by virtue of the 90-day clock expiring. In addition to that, it is very difficult to see how anyone could hold such a DOE accountable if they're simply relying on the passage of time, if this bill were enacted, to automatically approve LNG exports. If all they have to show is 90 days has lapsed, then what is the basis for challenging that and trying to hold DOE accountable for doing a real analysis and protecting the public interest? So in short, there are other provisions of the bill. We have a lot to talk about today, so I'm happy to answer questions about some of the other pieces of the LNG provisions. But in the interest of moving this forward, I just want to be clear. The bill is designed to facilitate the approval of LNG exports. And we can disagree over maybe how many of those exports should ultimately be approved, but jeopardizing our ability to hold DOE accountable for protecting the public interest and allow projects to go forward just because 90 days elapses is not how we ensure that these decisions are made with the full set of interests to protect the American people in mind. Thanks.
Thank you so much, Moneen. And just as a reminder, we are recording the presentations today, but we will not be recording the question and answer session at the end. And also, just as a reminder, I dropped this in the chat, but do feel free to add your questions to the chat and we will endeavor to get to them as much as we can. With that, I want to introduce Justin Meuse with the Wilderness Society to discuss both the offshore and onshore oil and gas provisions. Justin, the floor is yours.
Thank you, Erik. And before I get started, I'm going to share my screen and present a PowerPoint presentation to accompany my presentation here. So bear with me as I pull that up. Let's see. All right. Excellent. Again, my name is Justin Meuse. I'm the Director of Government Relations for Climate and Energy at the Wilderness Society. We work to protect our nation's federal public lands and waters, and we've been thoroughly engaged on the Energy Permitting Reform Act since its introduction in July, primarily on onshore oil and gas, renewable energy, mining, and NEPA, but also on offshore renewable energy, which I'll talk about today, or offshore oil and gas, as I'll talk about later today. So I want to provide a little bit of context, but before I provide some context on exactly how the onshore oil and gas provisions in this bill work, I I don't want to bury the lead. Section 203 of the bill is the one with which we have the most concerns about from an onshore oil and gas perspective. And all of our concerns about onshore oil and gas kind of radiate around or radiate out from this this particular provision in the bill. That provision of the bill targets private and state lands overlaying millions of acres of federally owned oil and gas. So I included this graphic on the right just to illustrate what BLM manages. So the Bureau of Land Management under the Department of the Interior manages about 30% of our nation's subsurface and about 10% of our nation's surface. You'll notice a significant delta there, and that's because there are a lot of lands where BLM manages the subsurface and the surface may be managed by another federal agency. It could be a wildlife refuge, a national park, another unit of federal land, or it could also be managed by a tribal government, a state, or a private landowner. And Section 203 really goes into the process for states and privately owned surface. So the status quo right now for how the Bureau of Land Management manages these lands and the drilling process is BLM coordinates the permitting process for all applications to drill into federal minerals, so federal oil and gas and other minerals. It also is in charge of the permitting process for permits to drill through oil and gas, maybe not producing from the federal oil and gas, but through as well. And that federal permitting process is really important for a number of reasons. That's where the National Environmental Policy Act is enforced. The Bureau of Land Management also ensures compliance with the Endangered Species Act, with the National Historic Preservation Act to make sure that cultural resources aren't being disturbed or harmed when drilling occurs, and other bedrock federal statutes are followed. And the BLM also has an obligation to make sure that that safety regulations are followed as well. But perhaps most importantly, the federal drilling permit process is essentially the public's last chance to weigh in on a proposed oil or gas drilling operation before digging and drilling commences. And, you know, according to BLM's own testimony back in July 2022 on a bill with pretty similar language to this, you know, that last opportunity is a really important time to identify, you know, health issues that could arise from drilling or impacts to water or other resources. So what does the bill do? So Section 203 puts states and state laws in the driver's seat for drilling permits instead of the federal government in those circumstances where federal minerals are being accessed from non-federal surface. It stipulates that, you know, the federal share has to be less than 50% within the spacing unit, but nonetheless, federal minerals will be being accessed, and those are owned by all of us. Those are owned by you and me and your constituents, and we believe that NEPA and the other bedrock environmental laws that apply should apply to access those. And importantly, Section 203E of the legislation would prohibit the Bureau of Land Management and the Secretary of Interior from enforcing bonding requirements, so mitigation requirements and collateral requirements on oil and gas wells that are permitted in those circumstances. So what are the implications of this? So we see this leading to drilling on potentially millions of acres of Western lands that would be exempt from these bedrock federal environmental laws, public input requirements, safety standards, and taxpayer protection mechanisms, instead deferring to a patchwork of state laws that are oftentimes far less robust than their federal counterparts. We'd see new wells drilled on these acres that would not be subject to federal bonding requirements. Many of you may be familiar with the BLM's recent oil and gas leasing rule that raised those bonding requirements for the first time in half a century. Those new wells drilled in these circumstances would not be subject to those bonding requirements and would instead, defer to state requirements. And there are already thousands of wells in these circumstances too. And it's unclear exactly what would happen with the bonding requirements for those thousands of existing wells. And just to illustrate how this kind of split estate piece interplays with other parts of the bill, I want to harken back to Section 201A of the legislation, which requires that in order for wind or solar rights of way to be honored by the Bureau of Land Management, they have to have offered 50% of what industry has nominated in the past 2 years. So you could see a scenario in 2 years where industry flocks to these areas where they know they'll get drilling permits, in a far more lax environment, and then the BLM will be tasked with picking which 50% they're going to let go. And I want to touch briefly too on offshore oil and gas leasing. So Section 301 of the legislation, it's unambiguous. It requires one offshore lease sale at least per year for the next 5 years. And per the tethering requirement that was enacted in the Inflation Reduction Act, those lease sales must offer at least 60 million acres of our nation's oceans for oil and gas leasing, which is an area nearly the size of Oregon. The legislation also really hampers DOI's ability to update lease terms. The lease terms have to hew to what was finalized in the November 2023 lease sale, and that's especially concerning as well. I want to flag before moving on to the next panelist just a letter that was sent by 70 organizations and folks representing Gulf communities and coastal communities and frontline communities along the coasts that opposes this legislation. I'll make sure that this is sent around to all, but in particular, the letter illustrates that these are unacceptable provisions and should be and that the whole legislation should be opposed. So with that, I'll close and pass it back to Erik. Thank you.
Thank you so much, Justin. We'll now introduce John Leshy to discuss the mining provisions. John?
Hi, thank you very much for having me. I'm going to address briefly the hard rock mining piece of this legislation, which is Section 210. It's highly technical and easy to overlook, but it would significantly expand mining rights on public land. It would amend the antiquated mining law of 1872, President Grant signed into law. That law gives mining enterprises the right to extract hard rock minerals for free without paying anything to the owners of these lands, that is, all Americans, on hundreds of millions of acres of national forest and BLM land. But the vast majority of mines that would benefit from Section 210, I should note, produce minerals like calcium and gold and uncommon varieties of granite and clay and sand that are not strategic. That is, they are not related to the nation's clean energy future. Section 210 is misleadingly touted as a kind of minor technical fix of some problems that have cropped up in recent years in administering the mining law. But the case for Section 210 has 3 large defects I want to note. First, the so-called technical problems that Section 210 purports to fix are not flat barriers to mining. The hard rock industry is pushing for Section 210, primarily because they want to make it easier to use vast tracts of public lands for mill tailings piles and waste dumps without paying for them. Instead of pursuing other options that are readily available, but can cost them a little bit more or be a little bit more cumbersome to use. Second, Section 210's fixes not only make the mining law even more generous to mining enterprises, but could, depending upon how some of its ambiguities are interpreted by the courts, severely weaken the government's environmental regulatory authority over such operations. And third, if Section 210 were to become law, it would make true reform of this terribly antiquated mining law of 1872 considerably more difficult. Congress has been trying for decades with some near misses to reform that law. Section 210 would, if enacted, make it much harder to do that politically in the future. In short, in conclusion, although easy to overlook, Section 210 is a genuinely troublesome component of this legislation. It's highly technical. If anybody wants to know more about the details, please feel free to email me and I'm glad to elaborate. Thank you very much.
Thank you so much, John. We'll now introduce Dinah Baer, former Chief Counsel of the Council on Environmental Quality. Dinah?
Good afternoon. I am going to be talking about the provisions that affect the implementation of the National Environmental Policy Act. First, briefly in the Energy Permitting Reform Act. And then, so those of you who work in the House don't feel neglected, and because it may ultimately be related, I'm going to be talking about the recent bill introduced by Congressman Westerman to substantially amend NEPA. The overall theme in the Senate Energy Permitting Reform Bill in terms of NEPA is really categorical exclusions, not exclusively that, but there are several provisions that require the various secretaries to issue categorical exclusions within 6 months of the bill for various renewable energy projects, some small geothermal projects, and certain electric grid related actions. As a reminder, categorical exclusions are classes of actions that the agencies have determined through experience generally do not have a significant environmental impact. And therefore, the agencies don't need to assess the effects in an environmental assessment or an environmental impact statement. They do need to be cognizant of any, quote, extraordinary circumstances that would lead the agency to have to prepare typically an environmental assessment. Categorical exclusions are remarkably easy to get. And I think it's fair to say, although nobody's counted, that most actions in the federal government are categorically excluded. Agencies have dozens of pages of actions that are categorically excluded and maybe half a page for EISs, for example, actions that are required, that trigger the requirement for an EIS. Both Congress and CEQ recently made it easier to get categorical exclusions. So there's really no reason for Congress to be requiring and pushing agencies to do more CEs, which is a trend that has occurred over the last 15, 20 years, and can really lead to agencies feeling pressured to categorically exclude things that should not be excluded from routine environmental analysis. The bill also shortens the statute of limitations for lawsuits with NEPA claims from 6 years to 5 months. And it deems the approval of joint interregional transmission plans to be exempt from NEPA. So those are the major features there. I want to jump now to the Westerman bill. It doesn't have, as far as I know, a number yet. It was just introduced very recently, a discussion draft. It was the subject of a hearing last week in House Natural Resources, and I understand will be marked up next week and may be a must-have if the permitting bill goes over to the House. This bill would dramatically narrow the application of NEPA in a number of ways. First, it totally eliminates any federal funding from being a trigger for NEPA's application. So it doesn't matter if there's a grant or a loan or whatever for $2 million or $2 billion, NEPA just wouldn't apply if that was the federal hook, so to speak, if that was the federal trigger. It also has another huge loophole just at the beginning, which is that it would allow any agency to avoid NEPA compliance altogether by saying, well, they comply with a law that has, quote, similar functions as NEPA. And so they don't need to do NEPA. For those actions that, in theory, still come under NEPA in the bill, the applicant would gain much more control. The alternatives would need to meet the applicant's goals, and the applicant would have to approve any request for a time extension, which, as many of you will remember from the recent amendments, are 2 years for an EIS or 1 year for an EA, but the applicant would have to now approve any extensions for that. It has some very interesting provisions on science and technology. It doesn't require the agencies to get any new science or technology related to potential environmental effects. It also says they don't need to consider any new science or technological development once the application, excuse me, a complete application is filed for proposed action or a notice of intent for an EIS is published. And unless they deem it essential to the decision and the new science or technology is already peer reviewed. But even under those circumstances, they are not allowed to delay a decision to wait and see and analyze what this new scientific or technological information might suggest in terms of effects of the proposed action. So really very much a, put the blinders on while making very important decisions for communities and public lands all over the country. It also has provisions in it that are pretty much identical to the petitioner's petition to the Supreme Court in a NEPA case that the Supreme Court took in late June that will be heard in the fall or winter, the 7-County Infrastructure Coalition v. Eagle County case, for any of you who are familiar with it, that involves an 88-mile railroad that would be carrying oil and gas to the Gulf for refining. And that case deals with the scope of analysis and whether or not agencies are required to analyze effects outside of their jurisdiction, and also whether or not the concept that is found in tort law of, quote, proximate cause should be overlaid on NEPA. And this House bill has pretty much word for word what's in some of the briefs on that case. Speaking of cases, it also would make major changes in major cutbacks in judicial review of NEPA. It would eliminate all judicial review for any actions falling under either a categorical exclusion or subject to environmental assessments, unless the environmental assessments are put out for public review and comment. Well, there is no requirement in the CQ regs to put out EAs for public review and comment. A few agencies do it for some things, but by and by large, most actions that are not subject to an EIS would be completely exempt from judicial review. When you get to what's left, those actions that are subject to an EIS, plaintiffs could only litigate claims related to what's already in the EIS, whether it's the effects analysis or alternatives. So yes, that is the subject of some litigation, but often plaintiffs want, whether they're counties, cities, environmental groups, whatever, want to litigate over things that the agency did not include in the EIS and should have. And none of that would be allowed. And finally, plaintiffs, any plaintiff that actually makes it to court and through all those narrowing gates would have to substantiate their claims by, quote, clear and convincing evidence, which is a standard that is a higher standard than probable cause. I'm not an expert in this area at all, but I did a quick Google and I noticed that one of the things that standard is used for in some states is avoiding capital punishment, which hopefully plaintiffs' lawyers would avoid that. But the point is, it's an incredibly high bar for plaintiffs in a construct that would essentially eliminate probably 85 or 90% of current NEPA litigation. which is the most effective remedy that we have. So with that, I will conclude, but also happy to address questions. Thanks.
Thank you so much, Dinah. We'll now turn to Leslie Fields, the Chief Federal Officer with We Act for Environmental Justice. Leslie, the floor is yours.
Thank you so much, Erik. Good afternoon. I'm Leslie Fields, Chief Federal Officer for We Act for Environmental Justice, an environmental justice organization based in Harlem, northern Manhattan, with very large membership base, 50-member National Environmental Justice Leadership Forum, and we also are the only environmental justice organization that has an office in Washington, D.C. We join our colleagues in dealing with this and opposing this problematic bill. And first, we want to be clear that the government cannot continue to sacrifice communities, especially as a means to achieve a clean energy future. The legacies of redlining, disproportionate pollution burden, and environmental racism must be remedied as we move forward and transition our energy economy. Environmental justice communities have been calling for a permitting process that protects public health and preserves community input, especially in communities of color and low-income communities who bear the brunt of pollution and disproportionate impacts of the climate crisis. This bill, the Energy Permitting Reform Act of 2024, fails to do that. It aims to make it easier for fossil fuel industry to continue polluting our communities. And while transmission buildup is critical for clean energy transition, it should address environmental justice and must never be done at the expense of communities. There are currently 5 pending LNG export projects, all proposed in EJ communities in the Gulf, CP2, Commonwealth, Port Arthur Phase 2, Magnolia, and Lake Charles, all concentrated in communities of color and low income already inundated with fossil fuel infrastructure. These projects have finished FERC reviews and are awaiting final approvals that this legislation could fast track. If approved and constructed, these facilities would generate emissions equivalent to 165 coal-fired power plants. In addition, they would make the nearby Black and brown communities sicker and our planet hotter. Another concern we want to uplift is the blatant attacks on meaningful and effective community participation. As mentioned earlier, in particular, this bill shortens the statute of limitations from 6 years down to only 150 days for judicial review of agency approval of energy projects. This bill does not mandate agencies to provide public notice of proposed agency actions. This extremely shortened deadline severely harms the ability of EJ communities to meaningfully petition their government for redress and have their day in court. Better, equitable, and viable solutions exist, such as the A. Donald McKeechin Environmental Justice Act for All, or EJ for All, HR 1705 S919, and the Clean Energy Transition Acceleration Act, CETA, which is HR 6747. These bills balance our need to rapidly scale up clean energy transmission and production while protecting communities in the process. The EJ for All Act requires federal agencies to provide early and meaningful community involvement opportunities, including tribal representation under NEPA, while proposing an action affecting an EJ community. The EJ for All Act importantly requires consideration of cumulative impacts and permitting decisions under the Clean Water Act, Clean Air Act. Communities have been advocating for cumulative impacts considerations in permitting and siting decisions for decades to address the environmental racism communities face while overburdened by pollution. The EJ for All Act ensures that permits will not be issued if the projects cannot demonstrate a reasonable certainty of no harm to human health and the environment. CETA, the Clean Energy Transmission Acceleration Act, aims to address transition bottlenecks in a way that strengthens the engagement process, for instance, installing experts to facilitate the relationship between communities and project sponsors, and including EJ considerations. We urge Congress to work directly with impacted communities and organizations to develop a plan to address the need for swift renewable build-out that benefits frontline communities without fossil fuel giveaways and bypassing essential community engagement. Finally, I want to make sure to say that addressing the climate crisis cannot be a numbers game of emissions calculation or modeling. This simple math is both myopic and does not adequately account for the public health harms and on-the-ground realities, the mental, physical, economic, social, environmental harms and realities for frontline EJ communities overburdened by pollution, compounded by climate disruption, flooding, heat. It's part of the cumulative impacts for these communities. And it is the stress of all of this compounded. As my colleague in the movement, Dr. Beverly Wright, says, just looking at the numbers got us Cancer Alley. We are concerned by the over-reliance on emissions modeling that has no grounds to uplift environmental justice considerations. Meaningful public participation must be centered and address cumulative impacts of pollution for affected communities to ensure a just, clean energy transition. Thank you for your attention, and I'm available to answer any questions.
Thank you so much, Leslie. And just want to uplift that comment about air pollution in local communities with the oil and gas provisions. It's not just about greenhouse gases, it's also about particulate pollution, ozone precursors, nitrogen oxide, sulfur dioxide. These are all heavily prevalent in fossil fuel dependent areas in my state, for example, the Permian Basin and San Juan Basin. I'll now introduce Matthew Davis, the VP of Federal Policy with the League of Conservation Voters, to discuss the transmission provisions. Matthew.
Thanks so much, Eric. Hey, everyone. Matthew Davis here, Vice President of Federal Policy at the League of Conservation Voters, or LCV. Very much appreciate being part of this august panel and for you all joining our briefing today. I'm going to be as quick as I can and focus, as Erik mentioned at the top, on the transmission provisions in the bill. I think we can all agree that we need to improve and build out our electricity transmission in our country, and particularly if we're going to electrify everything and transition to 100% clean renewable energy, which I think all of us also support. But that said, I think there's some differences in just how much more transmission we need to build, and part of that difference of opinion is around there hasn't been as much focus and modeling around how much energy efficiency and distributed clean energy and storage, reconductoring, and other grid enhancing technologies really can reduce the need for new transmission lines. There's a recent study from Grid Lab and UC Berkeley that estimates about 80% of the needed expansion in new transmission capacity can be met by restringing with better, higher performance wires, which is generally known as the term reconductoring. But all that said, I think it's probably safe to say we're going to need at least 50% more lines so that we can build out the clean energy future that we all want. Recently, Congress has passed a number of different changes to the way that permitting processes work, and also in giving more authority to and confirming authority to the federal administration on related pieces. So they, I think Dinah mentioned and others have mentioned that there were tighter timelines, deadlines that were passed by the debt deal, as well as making even easier borrowing from one agency to another, categorical exclusions, which many projects already go under. The Biden administration has also taken a ton of actions using those authorities and authorities that existed even before that, like around coordinated interagency authorization and permits program, the SITAP program that DOE recently finalized rules for. They're implementing more efficient clean energy permitting processes, and they're rolling out financial incentives both for the actual transmission to be built and for state and local authorities to better conduct the permitting processes around transmission. Those are both, I think, very, very important and needed things. And there was $1 billion in the Inflation Reduction Act that many of your bosses, helped get across the finish line, that allowed for more staffing and training for permitting staff at federal agencies. And that is also bearing fruit. There's a recent fact sheet, if you haven't seen it, it's fantastic. A fact sheet from the White House that outlines a variety of those actions that they've taken and a variety of the results that they have delivered in terms of cutting the time it takes to do environmental review, while also increasing the volume of projects that are going through review, which I think is testament to when you've got additional staff and money and attention and oversight over these processes with an administration that really cares about it, you can see results, and we are already seeing those results. So all of that said as sort of context for what I think is what I see is not as much urgency as some folks do around transmission. So I think people are quick to say we need more, we need more, we need more, instead of stopping and pausing and looking at the results and looking at where we are. One thing that's about to roll out that I meant to mention before I'll move on to the provisions in the bill are the national interest electricity transmission corridors designations have been proposed by DOE, and they will be finalized in the near future, and that helps provide a permitted expedited permitting process, allowing FERC to either approve or deny transmission lines after states have a year in which to act. So either the state acts in that year or FERC gets involved and they act. So in terms of transmission provisions in the Manchin-Barrasso bill, it would take away the DOE side of the NITC process, the national interest transmission corridors, and allow FERC to determine whether lines should count for being approved in this process. This could speed up the process. It would, it would take out the DOE aspect, and it might make states act more quickly, and have FERC play a larger role. That backstop authority for NITC already exists, so it's not like that is being created as a new thing in this bill. But because DOE hasn't yet finalized those corridors, we haven't seen exactly what the existing authority can produce. I will note that Representative Graves introduced a bill yesterday that would block part of this NITC FERC backstop authority. Basically, if any state objected to any projects that they were considering, they would not be able to approve them. There are also provisions in the Manchin-Barrasso bill that would authorize FERC to require regional grid operators, independent system operators, and independent and operators that are not considered ISOs like Bonneville, to conduct interregional transmission planning. And there are also provisions that would codify cost allocation that's similar to the cost allocation aspects, which we think are very positive in FERC's Order 1920, which is their recent order on regional transmission planning. Unlike the Big Wires Act, there are no minimum interregional transfer requirements in the bill, just this requirement to do interregional planning, interregional transmission planning. I wanted to mention briefly the provisions around the North American Electric Reliability Corporation, known as NARC, which may have a chilling effect, particularly on EPA setting power sector pollution limits. This provision doesn't explicitly take away authority from EPA as far as the words, but it is very likely that it is meant as a check on EPA's ability to set power sector standards, and would likely undermine EPA doing anything that was not supported by a NERC study if it were to be brought before the court. And it also would likely mean that EPA would be slower in finalizing rules until NERC studies had been done and entered into the docket. So overall, being unclear exactly how much this would affect EPA's setting power sector standards, but likely would have an impact in a negative way. I think I'd also mention, we heard a little bit from Dinah on this. Recently, the House has introduced and/or seen some action on legislative proposals that are even more damaging to NEPA and to public input and to our laws and processes to protect the environment and protect communities. The Westerman draft bill, as she went through, the FREE Act, which could potentially get rid of permitting altogether and it would turn into a 30-day box checking exercise that the project developer would basically run, and the agency would be a passive agent in, and the public and the communities would not be anywhere in any of that. In that aspect, that's getting marked up this week in oversight. And then there's this new bill from Representative Graves that I mentioned that would limit the beneficial transmission provisions of the Manchin-Barrasso bill, making its potential much, I think much less positive. I think it's really critical to view that these House developments in light of, or view the Manchin-Barrasso bill in light of these House developments, and makes pretty clear that the House has a very high price. The House Republicans have a very high price for getting anything good done, even higher than what's in the Manchin-Barrasso bill in terms of damage to the environment and communities. We've talked a lot about the negative. Leslie talked about some of the positive things that we support. I want to second that, plus one that. The Clean Energy and Transmission Acceleration Act has a lot of really great stuff in it around transmission and permitting and engagement. The Environmental Justice for All Act, of course, is the gold standard for what engagement and processes with communities should look like. And then I'd also mention the Clean Energy Minerals Reform Act, which would make it so that mining is done more safely. If your boss isn't already co-sponsoring those three bills, we would certainly encourage you to do so. I will stop there and turn it back to Erik so we have time for a couple of questions.
Thank you, Matthew. And I've been diligently trying to answer folks' questions. We'll get to a few of them here. We will be sharing the panelists' contact information, and we'll work to get answers back on all of these questions to folks as soon as we possibly can. First question up, this is for Moneen. Folks would like to know, if the Manchin-Barrasso bill were enacted, how much of the LNG provisions, such as the export changes, would depend on the party in the White House? What would it look like under a Harris administration versus a Trump administration?
I mean, I touched on this a little bit, and I know we're getting short on time, so I'll make this answer quick. And I think, Erik, you provided a good context also in the Q&A. But essentially, what this bill seeks to do is sort of take away DOE's ability or take away our ability to ensure that DOE is looking diligently at the public interest. I mentioned this earlier, but to the extent you have a Trump administration that is interested in approving every single LNG project that comes before it, then all they have to do is sit on their hands and wait for the 90-day clock to elapse. And not only does that mean all the LNG gets approved, as I mentioned before, it's pretty difficult to see how one would challenge the decision to do that if all they need to show is, look, the 90-day clock expired. Under a Harris administration, assuming that a Harris administration is looking to take that public interest responsibility seriously, then what this bill would do is really put the screws to how long they have to do that, how long they have to wade through really complicated issues that deserve adequate time and consideration. So I'm going to keep it quick at that because I think we have other questions and very limited time. Thanks.
Thank you so much, Moneen. Forgive me as I am managing all of my different windows here. A question was asked about net greenhouse gas emissions. Would anybody on the panel like to address that? As folks are considering whether to answer that, I will also drop a Twitter thread in the chat that I did a few weeks ago on some of the initial modeling results that I think still holds up well. Matthew, I am seeing your hand raised on that.
Yeah, I'll speak really briefly to the transmission side. I think we've seen a couple of different numbers trying to estimate the emissions reductions from improved transmission and getting more clean energy onto the grid. I think the RMI numbers are probably decently reasonable. There are some big assumptions that affect how big a number you get. And, I think they have estimated that about the grids would add transmission about half as well as the best performing grid operator currently is adding transmission. I think that's relatively reasonable. The third way analysis does not take that approach. They assume that all the grids do as well as the best operating grid operator right now, which I think is totally unlikely and overly rosy. I will stop there and let Moneen talk about the LNG estimate.
Thanks. I think it's really important to reemphasize the point that Leslie made earlier, which is when we look at GHG modeling, we are looking at only part of especially the harms that we really need to be considering in deciding whether or not to enact this bill. Those models do not account for the costs that will be very clearly inflicted on communities of color, particularly in the Gulf. Those are huge, huge health costs, and ones that we cannot turn a blind eye to by just focusing on a net GHG outcome. I would say from an LNG perspective, and there are a number of different numbers floating around out there, as with any set of modeling, there's a lot of debate as to whether the assumptions being made in those models are way too rosy with respect to leakage rates. So how much methane is being seeped out at every step of the processing, transport, and export facility and export process, as well as really overly rosy assumptions on how much of the LNG going overseas is going to offset the use of coal, as opposed to offsetting the use of renewables. And a lot of the assumptions and a lot of the numbers out there just assume all of it is going to offset coal. That is not a realistic assumption. Especially when you're talking about, and especially when companies are touting sending a lot of this stuff to Europe, where they're not using coal. So there are a lot of places that these models are putting in a really, really rosy set of assumptions with respect to LNG. And when you are talking about doing that in a context of removing DOE's either ability to prevent the worst case scenario, or if we're talking about more of a Trump DOE, where they don't care and they're going to let it go anyway, and then we have no ability to deal with or to hold them accountable. Assuming rosiest and best case scenarios is a very dangerous game, as well as I should just flag really carefully too, some of the rosiest numbers are based on the assumption that domestic prices will go through the roof and cause a tremendous shift in the domestic market away from gas. So before people start endorsing those numbers, they should understand what's baked into them, because there may be outcomes and consequences that are in fact not at all what your constituents want, but are very much what the fossil fuel industry would like.